Hi folks, you're with Tacitus Today, your pushback channel, and thank you for joining this audio live stream. In this essay, I'd like to talk about the gloating, because that's, I think, what you can really call it, the gloating of the US Attorney General and Justice Department and the various goons from the attendant agencies doing a big announcement, very stage managed announcement, Merrick Garland sort of fronting it, talking about the conviction that they achieved through exceptional levels of activism, in my view, the conviction they got of the Proud Boys. Now, the Proud Boys have been maligned quite viciously in the media, and they're all Nazis, which is the name they give to anybody who questions or opposes globalization. But the Proud Boys were talking about things like the mass immigration from the third world isn't really working out and that sort of stuff, and quite reasonably so. I think any sensible person would hold that view, but it's not a view the globalists are prepared to accept. So the Proud Boys have put, they've been active in street marches and so on. And whereas, the Black Lives Matter and Antifa can rampage the length and breadth of the country with impunity, as soon as the Proud Boys show their faces, then suddenly it's a major drama. Nazis! But they're not the ones who, Proud Boys don't burn things down, and the Antifa and BLM do. But no, that's all right. They're working to help globalization, whereas these other guys are questioning it. So we got to fucking get them, and we can start that by separating them from polite society by calling them Nazis, because Nazis don't deserve legal rights. Did you know that? You call someone a Nazi, then they've got no legal rights, and that's an acceptable way of conducting the law and the rule of law and jurisprudence, the process and procedure of law. That's an acceptable way of doing it. You're a Nazi, you don't deserve legal rights. A bit like in, say, the divorce courts. You're a child abusing, a wife batterer. Suddenly you have no legal rights, none. Not that you went in with very many, but you have even less now. So let's just have a look at this Proud Boys. Now, the trouble with the case was it was ideological, in my view. It was ideological from the beginning. They didn't have any evidence that there was any insurrection or anything of that nature, whether directly or indirectly. So when you politically and ideologically you want to get a conviction, but you don't have the evidence, and indeed the evidence does not exist. These people did not carry out or attempt to carry out or had anything to do with anything even remotely resembling a so-called insurrection. Then you have to invent the evidence, or you have to create a procedure that will result in a conviction when there is no evidence. So either one, now. Inventing evidence is a little bit difficult. You can do it, but it comes with some high risks. So the safer and surer way to go about this is from a point of view that you must get a conviction for political reasons, is to tamper with the process. So that's what I would assert, in my view, happened in this Proud Boys case, and indeed other Jan 6 cases where they got it. Now, if they can stand over people, threaten them and bamboozle them with threats, and don't sell these FBI goons and so on, sure, they know how to threaten and intimidate people. I mean, that's, there's a special political squad there. That's what they do. They know how to do this shit. Well, one assumes they're quite effective at scaring people, threatening them with all sorts of things. Most people, quite understandably, don't know the law or how it works, and they believe that for the most part that government institutions are independent and impartial and apolitical and rely on evidence and facts, and that's this sort of thing. And they're not really aware that over the last 20 odd years that the entire Western legal system has been infiltrated by globalists and is now completely political and ideological. Cases that are utterly irrelevant to the globalists, utterly irrelevant. They probably still do rely on evidence. But wherever there's an issue and it relates to the globalisation project or globalisation appearing to be, the propaganda around it and preventing those that question it from having a voice, whenever that's an issue, then the political ideological machine kicks into gear and just takes over that legal or quasi-legal process. So we need to just sort of come to grips with that if it's an issue the globalists are concerned about, then it ceases at that very moment to have anything to do with facts or for that matter, the law. It then becomes completely political, and then they just look at how they can slice and dice it. So there's a number of things. Now, typically the methods used to undermine or to undermine the legal standing of a case, if you will, is to simply withhold evidence. Now that evidence can be withheld, as in you just delete messages or texts or emails or letters or something like that, or any evidence that may favour the defence. It just magically falls behind the filing cabinet, or it gets deleted, or it gets lost in cyberspace, or whatever it might be. So that evidence is simply not made available. And only evidence that is incriminating is brought to the court. Now that's in due legal process terms, that's an outrageous travesty of the legal process. But we need to remember that the globalists infiltrated justice departments do this without even blinking. To them, their chase, as far as they're concerned, they've got it in their heads, but we're fighting Nazis, so we can tell whatever lies we want, conceal whatever evidence, make up any evidence we want, corrupt any process we want. We're allowed to because we're fighting Nazis. So we're just allowed to. Now, okay, well, where in the law does it say you're allowed to do that? Fuck the law. We're getting Nazis. Well, where in the Constitution does it say you can do that? Fuck the Constitution. Fuck the Constitution. We're getting Nazis. We're allowed to do anything we fucking want, getting Nazis. Well, hold on. How do you know they're Nazis? Because we say they are, you silly motherfucker. So this is the attitude that pervades the process. Now, I came across this sort of very first. I saw it in the divorce courts, where they could just declare, well, that father and husband, he's a child abusing wife batterer. What evidence do you have? Well, this social worker says that she thinks that he probably is. We did actually, we think he might have sympathies with fascism. What evidence do you have of that? I just think it. So this idea of ideologically asserting criminal intent or criminal sympathies, or alleging that it might be that they know somebody who knows someone else who might be someone who's the second cousin of a third, that guilt by association. So he's a straight white male. He's a Nazi. So he must be bad. Why do we even need to prove it? Why do we even need evidence? That sort of jurisprudence was widely used in the divorce courts. And I first saw it and I was flabbergasted by it, that it was a process of law, like a central part of how the divorce courts worked. And the place was stacked left to right with activists. Every document they wrote and produced, certainly that I saw, was shot through with Marxist phrases and Marxist language and ideological sort of assertions that somehow didn't require evidence. These people were just ideologically asserting that there was either criminal intent or a criminal act, or it might have been, or even that the person was of such a disposition that they might do those things at some point in the future, but hadn't actually done it yet. In fact, that was one that was widely used in the divorce courts. Mr. Billy Bob Smith is we saw that he had a history book about World War II, And in World War II, it includes Hitler, which includes fascism, which includes Nazi. Therefore, he might be a Nazi. Therefore, he might do this, and therefore that sort of ideological cascading, escalating sort of guilt by association. Now, that sort of architecture, if you like, of the legal process has now been transferred across, because it was an ideological process. It's now been transferred across and has spread across pretty much all areas of law, this political ideological approach. And this is the architecture that came in, for example, to get the Proud Boys or anyone associated with January 6th in reality. You were January 6th. We say January 6th for insurrection. Only Nazis do insurrection. Therefore, you're a Nazi. Therefore, you're a fascist. Therefore, you're Hitler. Hitler would do an insurrection. Therefore, you have done an insurrection or intended to do it. And therefore, your association with that means you are associated with Hitler. Quite possibly just had coffee with Hitler around the corner before you did it. Yeah. Denying it, motherfucker. So there's this, and it's incredibly childish, and it's something that can only be born in the fevered minds of people that mentally sort of don't go beyond the age of 16 or something like that. But it's an interesting way of going about it. Now, anyone that looks at that, be they a politician, a judge, a lawyer, or professor of law, or anything, should be aghast that this has happened. But in the interest of the globalization project and reshaping society, this is considered ideologically as quite an acceptable casualty. In the same way that Pol Pot would kill millions of people in Cambodia, Stalin would have millions of people killed in the Soviet Union, Chairman Mao in China would have millions of people, and this is quite acceptable. It's acceptable because we're producing an ideological paradise. We're reshaping the world into an ideological paradise. Therefore, any casualties are acceptable, whether it be millions of dead or thousands of years of development, careful development of impartial legal processes. We don't. It gets in the way of the idea. It gets in the way of paradise. Well, why should we give a flying fuck about facts and the law and evidence? Because we're making an ideological paradise here. Well, are you questioning it, you fucking Nazi? So they come in with this attitude of not only moral superiority, but a level of sort of sanctimony that you can barely describe. That they are not only allowed to this, permitted to do this, break the law, manufacture evidence, hide evidence, but they must do it. They must do it. In fact, it would be immoral of them not to do it because they're getting Nazis, and therefore it's all acceptable. Now, they don't seem to think ahead to one day other people might be in charge. They may turn around and say, "Oh yeah, well, we say that you are now the Nazis. What do you think about that?" "Oh, no, you can't call us the Nazis. The law won't let you. The law, evidence, courts. No, none of that exists anymore. You tore it all down." Oh, holy shit. I think we made them. So having a look at the jury selection, for example, somehow one of the juries, and I think it was the Proud Boys case, one of the juries was stacked to the rafters with pro-BLM, pro-Antifa, virulent anti-Trump type activists. Now, when you're selecting a jury, now in some jurisdictions you only get a certain amount of no's you can give. So, they'll bring out three jurors, and each side has each side has the right to say 3 no's. No, I don't want that guy, don't want that guy, don't want that guy. But then you can't say no anymore. In other jurisdictions, you can say, you can keep on going till you get a juror that you want. Now, somehow the defense of the Proud Boys, the lawyers defending the Proud Boys, somehow agreed to a jury made up of Proud Boy hating activists. How would that even happen? Now, either the entire jury pool was carefully selected beforehand to be, super pro Black Lives Matter activists, which seems impossible on a random basis. So, in my view, at least, clearly that was a setup. So that's a corruption of the legal process. Handpicking an entire jury pool of Proud Boy hating activists. That's one option. The other option is that the State Department or the Justice Department got at the defence attorneys and told them, look, these are the guys that, here are the names, Billy Bob Smith, Jimmy Jack Jones, here are the jurors that you will say yes to. And those were all handpicked, anti, pro BLM, pro Antifa type activists. But on a random basis, it's almost impossible to get a jury completely made up of activists, who are only on one side of the political debate. That mathematically, that's impossible. At least a quarter to a third of the jury should be completely independent, or the other side. But that you could get all of them as activists, it's simply not possible. So we can look at that and say, well, that was clearly also that you can pick an activist, you can get an activist judge. Excuse me, you can get a judge that's unusually sympathetic to the Justice Department's political ideological pursuit of the case. Unusually sympathetic. How do you even achieve that? Why does the other side, the defence, not file a motion against an obviously one-eyed, politically motivated activist judge? So there's a lot of things happening in just that administrative structure of that trial, in my view. Now, in addition to that, evidence that would have clearly proven that the Proud Boys had nothing to do with, had no intention of, had no association with any sort of insurrection, as they called it. To even suggest that or imply that's absurd. But to had anything to do with it, that evidence seems to have been strangely lacking. If you look at certainly what I've seen of it, the cross-examination of the witnesses, I thought was, substandard. I'd have gone in, I'd have chased a lot more things than the defence attorneys seemed to do. I'm assuming that the defence attorneys were either inexperienced, they were intimidated by, you'll never work in this town again if you put up a spirited defence for your clients, or they were told to take a dive, or were paid to, or something. Somehow, I think their defence of their clients was, to say the least, ordinary, and looks like they were kind of accepting that there would be a guilty verdict, and they were just going through the motions to give it the appearance of a fair trial, when in fact it wasn't. So really, the case was ideological and political against the Proud Boys, in my view, as indeed it was with other Jan 6th defendants. The charges and the rationale behind the charges was almost completely ideological, not factual. And that ideological stuff was completely accepted by the judge. Any independent judge should have struck that out, told the jury, listen, you ignore that bullshit that the prosecution had, but instead it didn't. It was allowed to go through. And also things like cross-examination. As an example, here's a divorce court sort of thing that I saw, where the father was being trashed by a social worker. He's a Nazi, he's a fascist, he's a wife-beating, child-abusing motherfucker, and just going absolutely to town on the... But it was all ideological, no evidence or anything like that. It was a completely ideological sort of take on, well, he's a straight white male, so he's a fucking Nazi. It was that type of... So when the attorney for the guy gets up to do the cross-examination, then the judge suddenly says, oh no, the court's closing early today, and I'm giving this witness leave, they don't have to return. So the defence attorney, wait, hold on a minute. My client's just been trashed to the high heavens here. We it's a due legal process. We have to be allowed to cross-examine this witness unless the court's going to dismiss the evidence. And the judge says, well, I'll consider the evidence. There's some things I'm concerned about in it, but I'll consider it. And I may or may not accept it as pivotal evidence. And But that witness, this is the social worker, has just trashed the father. that they're dismissed now as a witness. And if you want to bring them back, then you've got to make this guy pay like a $15,000 bond just to bring this person back for one cross-examination. So just in that little tactic there, the judge, in a predetermined case, the judge was preventing cross-examination of a witness, and that uniquely the man had to pay a $15,000 bond just so they could cross-examine the witness to bring them back, and the judge gave them leave and closed the court early. So clearly it's a tactic to prevent cross-examination. As it turned out in that case, the judge then relied almost 100% on this evidence, so-called evidence, which is nothing but an ideological rant. Relied 100% on the evidence made by this social worker, but not allowing a cross-examination of the social worker. So that was a clear violation of due legal process. But it's these little tactics that they use. So whereas they can give all day to the prosecution to make a case, it was an insurrection by Nazis, as soon as the defence rises to do their cross-examination, then the judge can close the court early, or they can say, well, that witness isn't available tomorrow or the next day. Oh, too bad. The trial's come to an end. You didn't get a chance to cross-examine her, or you've only got 5 minutes to cross-examine. These little tactics are used by the activist courts all over. And there's a little bit here, a little bit here, a little bit there, a little bit over somewhere else, but it's enough to stymie and frustrate and indeed prevent due legal process from being applied. So the other side's got carte blanche, open slather, to accuse the Proud Boys of whatever they want. But when the defence gets up to do something about it, then they're very restricted. I'm not saying this did or didn't happen, by the way. I'm talking generally here. These are the tactics they use. The activist, ideological, political police, which clearly the department in the US is. These are the sort of tactics they use. But they need the combination of the activist judge, a stacked jury. They need to bypass due legal process quite comprehensively, concealed evidence, and so on and so forth. So we need to accept this is now how business is being done in courts. It's, as you're probably aware if you've seen some of my other videos, a pet peeve of mine. For God's sake, don't fuck with due legal process and the rule of law. You want to fuck with some of the things, we can talk about that, but don't fuck with this. But instead, the rule of law and due legal process are obstacles to the globalist project. So they either have to remodel it so it only suits their own purpose, or trash it entirely, or both. By remodeling it to suit their own purpose, they are in effect trashing it. Now, so I'll close with something that's really concerning to me and quite staggering in a lot of ways. I'm surprised. I mean, Merrick Garland's Jewish, as you probably know, but I'm surprised by the amount of Jewish people who are at the forefront. Indeed, they are amongst the most intense cheer squatters. They just cheer squad and cheerlead the trashing of due legal process, trashing of the rule of law. Merrick Garland, in my view, is probably one of the foremost exponents in the world today of dispensing with due legal process and the rule of law in pursuit of political ideological objectives. Now, Mr. Garland's hardly a young man, and he has, one would assume, much experience in life and has been around the legal field for quite a while. Yet he openly gloats and rejoices about trashing due legal process and the rule of law, whilst at the same time being the nation's most senior law officer. He rejoices and gloats over the trashing of the very legal system and justice system he's supposed to be administering. I find that staggering. But there you go. But the amount of Jews are at the forefront of this. Now, if any race of people or group of people or part of society should be aware of how the law can be perverted and subverted and corrupted to go after a particular group of people who the establishment doesn't like, then Jews should understand that. If anything should come across in Jewish historical studies, is how the law has been perverted to target and persecute Jews. Now, whether the Jews have been been contributors of their own fate, or to what extent they ever were, is we can debate that separately. But if we look at the Nazi era, for example, and this sort of was kicking off, I don't know, particularly it got going 1936, 37, I suppose, around that time, maybe a bit before, but it certainly picked up around that time. The Nazi courts who had, they started to appoint activist judges, and the sort of things they would do, and I've mentioned this in previous things, the sort of things they would do to the Jewish defendants was they would lower the bar very considerably for someone to bring a charge or allegation against a Jewish person. So instead of meeting a standard sort of a bar of evidence, a Jewish person did this or that. Do you have witnesses? What evidence do you have? That it really it was allowed to be an allegation alone was enough to drag some Jewish person into court. Now that's always a bad sign, as you can imagine. That sort of lowering the bar. But if we see it today, straight white male, anyone can accuse me of anything. And that's, of course, very concerned, unless you're part of the globalist power elite, of course, then you're immune. But so that was how they could get the Jews into court. But then they subverted Jew legal process, because these people, the Jews, were being brought into court, not every single one of them, but many of them just on an allegation alone. So there was no evidence, or there was only a say-so evidence, no supporting or corroborating evidence or independent evidence. So it's a very weak basis for getting a conviction. So, and any jurist anywhere throughout human history knows that. So you have to subvert other areas of the legal process in order to get a conviction. And denying evidence, hiding evidence, concealing evidence, frustrating the defence are as big an issue then in Nazi Germany as they are today in the United States under Merrick Garland. The same sort of thing. So a Jewish guy in the United States today is presiding over the same subverting architecture, exactly the same subverting architecture that the Nazis used against the Jews in 1930s Germany. Do you think, why are so many Jewish people cheer squatting this on? I mean, for fuck's sake, have they learned nothing of the past or from the past? So then the Jewish guy would be, or person, I'll use guy in this instance, Jewish guy would be dragged into court, and then the judge would, for example, would say, okay, well, we're going to have the hearing right now. And the Jewish guy would say, well, hold on a minute, I haven't brought my witnesses. I thought this was just a directions hearing. I didn't know this was going to be a full hearing. No, I'm having a full hearing now. Where are your witnesses? Well, I haven't got them. I didn't know it was going to be, the summons I got to court here wasn't that there was going to be a full. Well, I'm deciding there will be a court hearing, says the activist judge. You've got no witnesses. Well, then you can't disprove the allegation. So you're guilty. That's it. So it's by using these devices to deny due legal process, that's an example of it. Not dissimilar to a lot of things that are going on today in the US, in my view, and elsewhere around the Western world. They were able to secure convictions of Jewish people, not because they were guilty of anything or guilty of the matter as charged, but simply because they would frustrate and deny them the ability to defend themselves, or to call witnesses, or to produce evidence in proof. Or another device they use, which again I've seen this, is how they raise the bar. So they can say to Jewish, well, you have to prove you weren't in the town at the time. If we're going, well, as a matter of fact, I can prove that, and here's a receipt from the purchase I did in the town 100 miles away. Okay, well, the court has decided you must have 2 receipts. One's not enough. So the Jewish person, well, as a matter of fact, I do have 2 receipts. Oh, yeah, well, the court says you must have 3 receipts. Well, I haven't got 3 receipts. Well, therefore, you're guilty. That type of thing. And these are again, I would suggest these are the tactics that we use against the Proud Boys. But we all need to be very, very concerned. Having Garland up there gloating and preening about how the fuck he secured convictions and so on. I'm protecting democracy from Nazis. That is bullshit. Total bullshit. Here's a Jewish guy that should know better, that's using the same tactics, in my view, that the Nazis used in the 1930s, or that the communists used against the Jews in Soviet Russia, using the same sort of subversion, legally subverting tactics that we used there in order to secure a political ideological conviction. We must all of us get up and talk back against this. You've been with Tacitus today, your Pushback channel. Thank you for listening.